Our seminar this afternoon on the proposed block exemption from the Competition Act for South African exporters, which was recently published by the Department of Trade, Industry and Competition for comment. This notice, of course, comes at a very critical time as the American tariffs reshape global trade dynamics, and there has been plenty of concern voiced about the impact of these tariffs on South Africa's export revenues and, of course, on government's ongoing efforts to create jobs and shore up the local manufacturing base. Whilst this proposed block exemption does open up some very interesting collaborative opportunities for our clients, and may enable our exporters to strengthen their global competitiveness, it may, of course, also pose some challenges and carry some risks. So we thought it would be great to arrange this seminar to unpack this a little bit more, to think about what the proposal is and how it's likely to work, and of course also to get some perspectives from colleagues in the Americas who can give us some insights as to what the risks from that side might potentially be, and look more broadly at how this fits into the strategies to be adopted by South African exports. So thank you very much for joining our seminar today. Please feel free to put any questions that you might have in the chat box, and we will definitely make sure that there is a little bit of time at the end of the session for people to ask some questions if you'd like to come online and do so. But before we kick off, I'd like to just briefly introduce our speakers who've agreed to join our panel today. First up is Hugh Holman. He's a partner at Baker Botts, based in the firm's Washington office, and his experience includes serving as the attorney advisor to Bill Kovacic, a former chair and commissioner at the US Federal Trade Commission. Next, we have Kolofelo Kruger. She's the head of trade law at Besso, a Swiss trade compliance technology company, and also a Bowman's alumni, I realized. Next up, we have H.B. Senecal. He's a partner in our competition team in Johannesburg and also one of the leaders in our trade practice group. And last but not least, we have Xolani Nyali, a partner in our competition team in Cape Town and a leader in the firm's African Continental Free Trade Agreement focus group. So maybe just to kick off, HV, can you give us a sense of what this exemption is all about and how it's proposed to work? And I suppose most importantly, for companies that are logging on this afternoon, how do we expect, what kinds of conduct do we actually expect it to cover?
Thank you, Heather, and good afternoon, everyone, and thank you for the opportunity to share a few thoughts today. South African exporters are under pressure. We've all seen the impact of rising tariffs and tough competition in global markets. The most recent example is the heavy tariffs imposed by the United States. That crisis is what spurred government to actually act quickly. But it's very important to stress this new draft block exemption is not about the US only. It's a broad framework that applies to all export markets, the US, the EU, Asia, Africa, anywhere South African firms are selling goods. It's designed to make it easier for our exporters to work together legally in ways that would normally raise red flags under competition law. It bears noting, however, that the block exemption is still only in a draft format, and we're still expecting a final version to come through. So what collaboration does it allow? Normally, when competitors sit down to collaborate, lawyers like me or us get very nervous. But the government has recognized that in export markets, certain types of collaboration are actually good for competitiveness and jobs. The exemption specifically allows exporters to coordinate to achieve economies of scale and efficiency in export markets to improve competitiveness. It also allows exporters aimed at sharing logistics, for example, citrus growers, pooling and cold storage and container space when exporting to the EU, and sharing costs of shipment and insurance. The exemption also allows exporters to coordinate on funding and share market intelligence, like information on import regulations and product regulations in export markets. It also allows to market collectively. Think of wine estates, for example, promoting South African wine under a single campaign in China. It allows also for coordination on joint negotiation of protocols and quality specifications in export markets. For example, changes in EU labeling rules or US phytosanitary requirements. It allows for co-investment in infrastructure, like steel exporters, For example, coordinating in relation to joint financing and development of infrastructure required for exports, like upgrading an export terminal at Richards Bay together. This somewhat ties in with the recent block exemption for ports, rail, and key feeder road corridors, which we will unfortunately not have time to cover here today. The block exemption is also aimed at assisting with offset on landed costs. Exporters agreeing on how to spread costs like insurance or port fees. Does it allow for price fixing and market allocation? I think that's the key question on everybody's lips. Now, the question that always comes up is, what does an exemption allow for? Price fixing or market allocation between parties, in this case, exporters? The short answer is potentially yes, but only in export markets and within strict boundaries. Because the exemption lists sections of the Competition Act that normally ban price fixing and market division, exporters could, for example, agree on a common selling price in a foreign market. So citrus growers, for example, don't undercut each other in Rotterdam and weaken everybody's position within the European retailers. Allocation of territories may be one, for example, one group of wine producers may focus on Asia, while another one takes on West Africa to avoid oversupply in one region. Fix certain purchase prices abroad, for example, agreeing collectively on the inspection or certification costs paid to foreign authorities. But let me stress again, none of this applies at home. This exemption does give exporters somewhat of a free pass to collude domestically, but as long as the effect is not felt back home. It's strictly about helping South African products compete abroad in any foreign market, not just the US. What does this block exemption not cover? It's equally important to be clear about what the block exemption does not allow. First, it does not apply, as I said earlier, to the domestic market. Second, even in export markets, the exemption is about coordination at the business-to-business level. Exporters dealing with foreign importers, distributors, or wholesale buyers. To wit, coordination cannot apply at customer or end consumer level. That's a very important distinction. Another factor that's excluded in exemption is the practice of minimum resale price maintenance. It does not extend down to the end consumers. For example, wine estates can agree on an export price to a Chinese distributor, but they cannot dictate what that distributor ultimately charge Chinese consumers in retail stores. Any conduct that can reasonably tie back to the export promotion will fall outside the safe harbor, and the Competition Commission retains the right to step in if arrangements go too far. Finally, the block exemption does not cover mergers and acquisitions, and these must go through the normal competition review process. Let's just quickly chat about the procedure and how does it work procedurally. In practice, exporters can't just act on their own. They must submit a written request to the Competition Commission describing their planned collaboration. The Commission has 30 days to respond, and if it doesn't, the conduct is deemed approved. Exporters must keep accurate records and notify both the Commission and the Department of Trade and Industry within 7 days of implementing their arrangement, and approvals can be revoked if exporters step out of line. So it is flexible, but certainly not a free-for-all. What makes this block exemption better than a normal exemption process? So why does this matter for our clients? Why is a block exemption better than the usual exemption process? It gives speed and certainty. Instead of months of back and forth on an individual exemption, exporters get clarity quickly, often within 30 days. There's reduced legal risk. By operating under a defined framework, exporters know they've protected against allegations of collusion. Economies of scale, where it's, for example, whether it's auto parts suppliers pooling shipments to Germany or mining companies sharing rail capacity, the savings can be huge. Inclusivity, by requiring participation of SMMEs and HDP-owned firms, it helped broaden economic benefits. And stability. It's valid for a 5-year period and gives exporters a reliable framework to plan investments and joint projects. So in closing, the block exemption is a game changer. It recognizes that in global markets, sometimes South African firms need to compete together, not just against each other. Yes, it may even allow things like coordinated export pricing or market allocation, but only abroad with clear safeguards. My advice to exporters is look closely at where collaboration could cut costs or open new markets for you and engage early with the Commission to make sure you benefit. Thanks, Heather.
Thanks, HB. Certainly seems to be something that presents some great opportunities. Maybe Koglani, over to you. Do you see any sort of challenges or risks inherent in participating in this kind of process?
Yeah, thanks, Heather, and hi, everyone. I suppose there's two broad buckets where I could identify some risks and perhaps disadvantages in relying on the block exemption, and it's double-edged sword. So some of them have been mentioned by HB, but in a more sort of positive sense. But we need to look now on the flip side of it, because again, these things tend to have two sides to it. So the two buckets for me is on a substantive basis and on a procedural basis. So Judd, I think will talk a bit more on the substantive aspect of it, but the first, that is quite an important starting point, which is to consider whether is the conduct that you want to engage in actually one that contravenes the law, right? Because putting yourself into this process presupposes that the conduct that you want to engage in is problematic from a competition law perspective, and therefore warrants an exemption. And Judd will talk a bit more around what that actually means. So for me, that's a big point to start off with. Once you've sort of gotten over that hurdle, and then of course there are these benefits of, as HB mentioned, which is it's much quicker than an ordinary exemption, which can take up to a year. But you still have to apply, right? So even once you've determined that your conduct was within the scope of the exemption, you still have to go to the Commission. And the Commission has up to 60 business days, right? So the first 30, and then it can extend by an additional 30. Again, when you juxtapose that against a year, still looks pretty good, I suppose. But here's the sting of this, and that is the Commission requires you to keep every record of correspondence, minutes, documents, which I suppose would be for the duration of that exemption that's granted to you. And you may need to disclose that to the Commission on request. Now, that is obviously going to give the Commission incredible amounts of insight into your business, your thinking, over a very long period, however long that, let's assume that your exemption is for the duration of the current block exemption, which is 5 years. The Commission will now have that correspondence over 5 years. It may not be problematic legally, but it will give insights, right? So you've got to think about that. Obviously, also just the obligation of keeping all of that information for that period of time. And then, of course, informing them within 7 days of when you implement. As to when does implement, it's like asking how long is a piece of string. So there's just practical things that one has just to consider and be comfortable with. But as I said, I think the main two is just that procedure, that substantive point, which Judge is going to talk about, and again, the insights that the Commission may get to your business.
And I guess, Golani, that you end up in a sort of quite a cozy arrangement with a firm that's your competitor in South Africa in other respects, right? So you've got a bit of an ongoing compliance headache, maybe.
Correct, precisely. Again, and the longer the exemption, of course, is, the more that entrenches, and then it becomes somewhat a challenge to untangle.
Yeah, absolutely. I think that's a good point. Hugh, I'm going to move to you, obviously sitting on the US side of things. We're very interested to hear about how this kind of coordination by competitors in particular might be viewed under US antitrust law. You might be able to give us some insights about how your authorities would think about these things.
Thank you, Heather, and thank you, Bowmans, for the invitation. It's a real pleasure to be here today. So in South Africa, as HB and Zulani have described, the block exemption framework lets companies team up for export purposes, and it's conceived as a way to better compete on the global stage. But you take that exact same activity and look at it through the lens of US law, and suddenly it's not a tool. It's potentially evidence of a hardcore criminal cartel. So that's the big question, isn't it? How does one single action be both state-sanctioned in one country and a serious federal crime in another? And the answer lies in the very, very long arm of US law, which does not stop at its own borders. Okay, so to fully understand this, we first need to understand how US law can apply to things happening completely outside the United States. And the whole idea is called extraterritorial jurisdiction. It boils down to the legal principle called the effects test, and it's actually pretty simple when you think about it. If your business activities, no matter where they happen in the world, create a ripple effect that hits the US market in a big, predictable way, such as by increasing prices or impacting supply, then congratulations, you've very likely popped up on the US Department of Justice's radar. So this isn't a vague idea, it's a formal three-part test. So first, the effect has to be direct, and we're not talking about 6 degrees of separation or a butterfly effect type of thing. It has to be a pretty clear cause and effect. And second, it has to be substantial. A tiny trivial impact won't be sufficient. It has to be significant. And then it has to be reasonably foreseeable. And generally speaking, if you have exporters and you're planning on exporting to a massive market like the US, you probably have a sense as to whether or not it's going to impact the US. All right, so now we know how US law can reach you. The next big question is, what exactly does it forbid? And I will preface this by saying that the exemption has a lot of different activities, and not all of it is necessarily going to be a problem in the United States. But let's just turn it to how the US antitrust law would analyze these types of conduct. So there are different levels of risk, and one of them is basically a legal cliff you do not want to fall off of. So US law takes two completely different paths here. First, you've got your per se illegal conduct, which is an absolute danger zone. Things like fixing prices or agreeing to divide up markets are considered so bad, so inherently anti-competitive, that they're automatically a crime. And everything else falls under the rule of reason, which is more of a balancing act, where you can argue, hey, what do we actually have some good effects here too. It's not all bad. And this is where the rubber really meets the road. So let's quickly look at a couple of examples. So let's say you're jointly financing a new company. So that probably has very low to moderate risk, and you can likely make a very good case under the rule of reason. Well, what about sharing market information? Well, that risk level there would be much higher, because that starts to look a whole like you're coordinating your next moves. And then there's the big one, which is coordinating directly on prices. In the US, there's another name for that. We simply call it price fixing, and that's a per se crime, and the risk level is severe. And we're talking criminal charges. And I want to be crystal clear. This is not a theoretical legal debate. The consequences are incredibly real. We're talking about huge fines and actual prison time for executives. But the good news is there are concrete steps you can take to stay safe. But please don't think these are empty threats from the US. So, for example, Romano Pisciotti, he was an Italian executive involved in a marine hose cartel, and he was extradited to the United States to serve 2 years in a US prison. There was Maria Olings. She was a Dutch executive. She was part of the air cargo cartel, and she ended up serving a 14-month sentence in the US after being extradited. And there are other examples too. So the message from the US prosecutors is loud and clear. We don't care what your passport says or where you live. If your actions harm the US market, we will come for you. So how do you avoid this nightmare scenario? First, you should seriously analyze whether your collaboration could have that direct and substantial effect on the United States. Second, you have to know and avoid the red lines. Avoid agreeing on prices, markets, or production levels with a competitor, period. And then third, if you're doing a joint venture, it has to be real economic integration. And finally, and this is probably the most important thing I can tell you, do get expert advice from qualified US antitrust lawyers. Relying on your local laws is not going to be a defense here. And really, that's what it all comes down to. In today's world, your business operates on a global stage. The borders are blurry. So the most important question you have to ask yourself is this: is your legal compliance program as global as your business? Because when it comes to US antitrust law, what you don't know can hurt you.
Thanks, Hugh. It's very enlightening indeed. I mean, it seems to me one would have to spend quite a bit of time with your US counsel thinking about the specifics of your proposed collaboration. So you could, for example, decide that you want to share the cost of shipping, and then might have to have a debate about whether agreeing on the price that you all pay for your share of the ship is something that has a direct and substantial effect in the US. And then whether that kind of collaboration is necessarily regarded as something which is a per se problem in the US. So it would be a very case-by-case analysis, depending on the particular conduct that you're thinking of undertaking under the block exemption when it gets passed in South Africa.
I think that's exactly right, Heather. I think, as I was describing, there are definitely some red lines that you need to stay within. But when it comes to the general forms of collaboration, there are certainly mechanisms in the United States for an evaluation under the rule of reason as to whether or not that specific collaboration is actually going to raise antitrust risks. And working with counsel to work through that, and the perception that the US agencies and whether or not there's precedent for a particular type of collaboration you can work through and find a way through. And yes, again, Heather, I mean, if you stay away from those red lines, there's usually a pretty good case to be made as to why antitrust risks are low, or find another way to work through it such that you avoid any of the antitrust risks that might ordinarily have been incurred.
Yeah, thanks. That's very interesting. Judd, it seems to me that the same kind of mental exercise is one that can also be done in South Africa. And you might, in some instances, even question whether a block exemption is really necessary in order to achieve some of this collaborative conduct, depending on whether we properly characterize it or not. Do you agree with that?
Absolutely. Thanks, Heather. And it ties in nicely with what Hugh has said. So when you have a look at this block exemption, it's got to be contextualized in light of the manner in which the Commission has approached Section 4.1b of the South African Competition Act. And Section 4.1b is what prohibits cartel conduct. So that's price fixing, market allocation, and collusive tendering. And you can't look at that type of conduct through a conservative lens always, which the Commission sometimes does. So it's not to say that all competitor collaboration that is efficiency driven leads to collusion. And in this regard, just like the US, our Competition Act distinguishes between those hardcore per se offenses, such as price fixing, and other forms of competitor collaboration, which may be justifiable if they produce efficiency or pro-competitive gains. And this is also supported by our case law. The Supreme Court of Appeal in the ANSAC case said, your starting point is that you've got to consider what is the character of this conduct, and that's key. So again, not every action that's going to result in similar pricing or a joint action is a cartel. You've got to look at the purpose, you've got to look at the structure, you've got to look at the effect of the matter that's being collaborated on. So many forms of export collaboration are not going to be cartel conduct. They're not going to be anti-competitive. They're not going to result in contraventions. And if you have a look at the draft exemption, it actually acknowledges that in a way. And the reason I say that is because in Section 3, it lists things such as sharing of export-related market information, and it mentions regulations and product standards. It refers to collective marketing of South Africa, Inc., industry negotiation of export protocols. Now, those do not have the character of cartel conduct, nor are they cartel conduct. If you then go back and have a look at the Competition Act, and the exemption does cite Section 2 of the Competition Act, which explicitly aims to promote efficiency, adaptability, and South African participation in world markets. These objectives can be achieved through well-structured, pro-competitive collaboration without the need for actually going for a blanket exemption. And And it ties back to what Hugh has said, is that there are legitimate ways to achieve these types of things, and you've got to look at those legitimate ways. And the reason for that is that South Africa, you may be fine, but ultimately, if you have a look at what Hugh said in the context of the US, or even if you're having a look at European markets, you could fall foul of their competition laws. Also, to tie back to what Xolani has said, when you're seeking a block exemption, procedurally, it's a nightmare. It's time, it's cost, it's ongoing compliance. You have a look at the aim of the block exemption, which is to promote the ability of small to medium-sized enterprises to participate in those export markets. Well, when they're looking at trying to achieve an exemption, the effort and that ongoing 5-year monitoring is probably going to be disproportionate to them if their conduct is clearly not anti-competitive. So yes, an exemption is going to be a useful tool in times like crisis such as these with sudden tariff hikes, but it's not the only or even the primary route for exporters to collaborate. So as Hugh said, you may be able to form a legitimate joint venture and to participate in those export markets, provided it's not a sham to fix prices or allocate markets, then you're okay. In the South African context, formation of those types of joint ventures is not always going to meet the definition of a merger, or even if it does, meet the thresholds for mandatory merger notification. So on that basis, it's a much quicker and far less costly exercise to pursue than going for this exemption process. And even if you had to notify these mergers, let's say you did so voluntarily because they fall below the thresholds, your period for approval is 60 business days. It's the same period at which an exemption has to be approved in. And again, there are other ways. So if you have a look at collaborative arrangements, if you form a consortium for logistics or marketing, again, those can be structured properly to avoid anti-competitive concerns, especially if they're open to participation by small to medium-sized enterprises or firms owned or controlled by historically disadvantaged persons, which is what the exemption actually encourages. Ultimately, though, it depends on the firm and the exporter. Where the collaboration is novel, or if it's close to the line, then you probably want to go the route of seeking confirmation or engaging with the Commission. That may be prudent, even if it's not strictly necessary. And again, key would be engaging with foreign counsel. So whilst, Heather, this block exemption is a helpful safety net, especially in the current trade climate, it's not always necessary. And you've got to look at how conduct can be properly characterized and structured, and what the legitimate means of collaboration are, not just under South African law, but in terms of the laws of the countries to which you're seeking to export.
Thanks, Jed. Kolofelo, maybe over to you. Important to get some practical insights here. Which industries do you think are likely to be hardest hit by the American approaches to tariffs? And what do you think some of the strategies are that businesses should be thinking about in addition to this kind of legal route?
Mm-hmm. Thank you so much, Heather, and thank you for the invitation. It's certainly good to be back home. This is where I started my career. Before I jump into the practicalities of the US tariffs, the South African sectors that are hit, I do want to make a small little comment on the block exemption, especially as it relates to international trade law, which is probably one of the laws that, obviously South Africa would have to comply with because it is a signatory to the Marrakesh Agreement. And so when I was looking at the block exemption, obviously it's not very, sort of specific. And of course, as always, the devil would be in the detail, but there's some language to the effect that coordination aimed at achieving economies of scale and efficiencies in export markets with the object of improving competitiveness of South African export products. And under the WTO agreements of subsidies and countervailing measures, export subsidies are per se prohibited. So there will be, an automatic violation of the agreements and export, Article 3.1 of the agreement of subsidies. And specifically, one of the illustrative lists of export subsidies that triggered my attention was this one that states the provision by government or their agencies, directly and indirectly, through government mandated schemes. And in the case law, of course, to this agreement, there's been some interpretation to a government direction of even private entities, is constituting an export subsidy or subsidy. And what's important here is that the terms of the exported goods would be more favorable than for the provision of like or directly competitive products in domestic consumption. So basically having more favorable conditions for exporters than for domestic products that would be sold domestically, which kind of looks like what's happening here. But obviously, as I said before, and there's always disclaimers, the devil would be in the detail. There would also be the attribution level, like how much can you attribute private actors' conduct to the DTIC or to the government of South Africa, for example. But this is something that I just wanted to raise as a point of information and also sort of tracking going forward. To my question. So as you know, South Africa, or the US, is South Africa's third biggest market, first being China, and then the EU, and then the US. And of course, this has been largely driven by the AGOA preference scheme, which permits duty-free or very preferential rates for African products to the US. In 2024, South Africa's export to the US was to the tune of $14 billion. And I'll just name off the top 5 sectors that exported. So first was precious metals and semi-precious stones. So this is about 8.5 billion, which is a really huge chunk of that 14 billion. And then we see vehicles, which obviously makes sense, automotive industry exporting to the US. We also have iron and steel, aluminium, and very, very closely followed by vegetables and fruit, citrus products, et cetera, et cetera. So these are actually, some of the industries that will be really hardest hit by the tariffs. It's also worth noting that some of these industries, for example, some of these products are exempted right now under the executive order that was actually issued in April 2025, and then also the other one issued on the 31st of July. And the product list hasn't changed in the exemptions. So we see a lot of exemptions for metals, for cobalt, for platinum, which is obviously of interest to the South African economy because we are major exporters of platinum, et cetera, and also gold, et cetera. So although there would be an impact probably for, I would say, autos, because they have, these tariffs, but also the Section 232 tariffs for autos exactly. Particularly, it looks that there's going to be a bigger impact on those industries and also industries like fruit that don't have an exemption than for the mining industry. So it is kind of a mixed bag. It looks like our biggest export items, meaning, mining items, or at least precious metals and precious stones, do fall into those exemptions, but not all of them, right? But those other products that don't are very hard hit. So I think we're looking at a very bleak sort of, prospect right now, 30% tariffs for most products that are going to the US. And some of these products don't have a lot of flexibility as to markets for selling. But I think, South African exporters have already thought about this probably already in April, now looking for alternative markets. And I think really the time is now to start looking at where can South African exporters be targeting. And I have a few ideas. I think especially for fruit and vegetables and sort of these perishable items, you cannot store them somewhere in a warehouse, for example, to try and avoid some of these tariffs, or hope that they're going to be exemptions, or they're going to be removed, as some of them have in the past few months. But some interesting markets would be the Middle East, would be markets like China and Japan, the East generally, and also the EU, although the EU is difficult from a sanitary and phytosanitary measures perspective. As you know, the citrus industry has been, having an ongoing uphill battle in the EU. But generally, when you comply with EU standards, it's a very, very lucrative market. And I think generally looking at markets that are, counter-cyclical, for example, where you can export South African fruits to the north during the summer season and vice versa, so that you don't have to compete with local products. So from a market sort of diversity or diversification perspective, I think there are many opportunities. I think there is a very big scale for the DTIC to support the industry, have those trade fairs, and start opening markets. And that's just really generally very good from a risk perspective, right? You don't want to put your eggs literally in one basket. So I think there are quite a lot of opportunities there.
Thanks very much. That's very interesting. So we've talked a lot about the potential impact on South Africa, on job creation here, on revenues here. But I guess, Hugh, there must be some debate going on in the United States about the impact of these tariffs on US consumers, right?
Very much so, Heather. So the FTC chairperson, Andrew Ferguson, actually issued a warning recently saying, we will be watching closely to make sure American companies are vigorously competing on prices, and that necessary tariffs should not be interpreted as a green light for price fixing or any other unlawful behavior. And the Department of Justice, which is the other agency which enforces antitrust laws in the United States, has come out with similar types of statements. So I think there's an awareness that with prices going up, that this might be an opportunity, or perceived as an opportunity by certain competitors to be coordinating some of their pricing. And so the antitrust authorities are going to very much scrutinize that type of pricing behavior going forward.
Very interesting. Thanks. I'm just going to pause there to remind our audience that you are so welcome to put your questions in the Q&A or any comments in the chat, and we'll definitely take the opportunity to get to them quite shortly. Maybe just back to Xolani for a second. Does this all signal potentially that we should be focused and more intense in our efforts to foster inter-African trade? And what role do you think the African Continental Free Trade Agreement might play?
Yeah, Heather, I mean, it is as if for once our leaders looked into the horizon and correctly read the tea leaves, that we may need to rely on ourselves a bit more on the continent and trade and so put in place the architecture to allow that to happen. And I do think there's a massive opportunity under AfTA, and we have seen a huge uptake even before the first tariff impacting the continent was announced. We saw impetus on the continent that we've never actually witnessed in terms of implementation of multilateral agreements, with countries publishing their provisional tariff concessions, schedules rather. I mean, you know, if you look at when the Protocol on Trade, which is the instrument that permits intra-Africa trade, that obviously is implemented by way of tariff concessions. And at the moment, as of April this year, 45 African countries have already published their unilateral concessions. 35 of those countries are already in a pilot program called the Guided Trade Initiative, where they're trading amongst each other, right? The tariff schedules have been already approved by the AfTA Secretariat. So there is that opportunity. The challenge for South African exporters is that automotive is not amongst those, unfortunately. But at least some of the fruit is part of the tariff concessions. And so in the immediate term, those could probably be able to the extent that they also, of course, meet the sanitary and phytosanitary measures of the countries that they want to export to, there's an immediate opportunity there. In the medium to long term, I think there's massive opportunity for diversification across the continent under AfTA. Let me pause there. Sorry, you're on mute, Heather.
Sorry, thanks. There's an interesting question, which is quite a good practical question. I think maybe Kolofelo can help us with this one. So, presumably there are alternative strategies available to businesses to be able to deal with the UF tariffs. And so the question is, where should a manufacturer turn to get advice on how to adapt their manufacturing process to take advantage of more favorable US tariffs?
This is actually a very practical use case that I'm currently dealing with. As I said, I'm working for a Swiss company, and although 30% is huge for South African products, Swiss products are facing 39%. So there's been a lot of questions that I've been facing as to, how do we deal with this? How do we reduce our tariff burden, et cetera, et cetera. And the first thing that I always say is that although I am a trade expert, I would really advise, as Hugh said, to talk to a US customs expert, really. But there are some practical, issues that have come up, or, advice generally that I would share with customers, with clients that come and seek our support. And so essentially right now, I think to keep checking for explicit exceptions, right? And exemptions. As you remember, gold was not on the list initially, but it was put on the list of exemptions. So the Swiss gold industry really won. They really almost passed out because they do export a lot of gold to the US. And so some products do get put on the exemption list. So just keep an eye out for that. And I think just essentially also tariff engineering and binding ruling. So, I mean, this is not available to all sectors in South Africa, and especially because, as you heard from the stats that I read before, we do export a lot of primary materials, commodities. So, but to the extent that, for example, maybe the auto sector can perhaps produce, or at least move part of the production to another country that has a more favorable tariff regime, that could be one way of trying to reduce the load, or exporting parts to the US, where you can also produce some of the product, or finish the product in the US. So essentially trying to get an origin or product origin that is not subject to 30%. It could be in the EU with 15%. It could be, in Eswatini next door that has 0%. So some of the things that some manufacturers can think about. The test here is, has the product achieved substantial transformation in order to obtain the origin of the final country of export? Other, thoughts that you can think, if a product, we feel really, I know there was a lot of sort of, stocking at the beginning of the year. If you feel that you've already sent enough to the US, there's, importing into the US, but, under a warehouse or free trade zone where the product does not go immediately into the US consumption, as they call it, but rather you keep it there until maybe there would be a change in regime, until maybe, in a few months, hopefully there will be a change of heart. But that's also a way to sort of, sort of relay or defer cash outlay, paying on tariffs immediately, but keeping it in the US so that if, once there's been a change of regime, and that product can go straight into the market. Just also, just to sort of caution, there is a lot of sensitivity in the US about transshipment. Actually, if exporters are found to have exported to a country to get, fake origin, you can face up to a 40% additional tariff and even higher penalties. So the customs authorities are very, very aware and wary of this. But there are some of these tips that I've shared with you that could be considered. And always, you have to then consult a US customs lawyer.
And would you say there are high levels of vigilance around that, Kolofelo? So is it something that is very actively being looked at in the current environment?
Absolutely. I would have to say anything that touches China right now is really an immediate red flag. I know this has been very difficult for ASEAN countries, especially Vietnam, Thailand, the Philippines, et cetera, So there have been some agreements with the US to try and, have a little bit of a deal around that. It was, I think, at some point, 35% or 40% Chinese origin, could hit additional tariffs. But this is, under negotiation also, I think, for Indonesia. I think they've sort of talked it down. But, any country that has a lot of Chinese inputs whether, even if you're producing in your own country or even transshipping, through your country. So China transshipping through Vietnam or Singapore or whatever could be a problem. I mean, for South Africa, obviously, because we're just so far from China, and with the transshipment, it would not be a huge problem. But, if it did happen, yeah, it's something that we just cannot entertain. But yeah, so also in inputs, right? We also have to be vigilant. If you're manufacturing in South Africa, just make sure that the inputs that you use also, don't stack, because some of these tariffs do stack, and you end up, with a bigger load than you would have faced before.
Very interesting, thanks. So there's another question which is directed at Hugh, I think, from somebody asking if we use the exemption, say, to export to the East and not to the US, would that still fall foul of the American antitrust laws? In other words, would you have a black mark against you for any future exports in relation to the US or some legal risk in the US? It's an interesting jurisdiction question, I guess.
It is a great question. So a couple of thoughts on this one. Firstly, I think if you do qualify under the exemption and you're flagging that you will be coordinating on pricing, then I think, yes, that's going to be a massive red flag for the US authorities. There's precedent for this. I mean, we're looking at De Beers and their cartel, the worldwide cartel, and they have been subject to multiple Department of Justice investigations over the years. So yes, you do flag yourself if you do comply with the exemption. Another piece to this to bear in mind is we're dealing, as I was talking about, an effects-based test. So even if you are exporting to another part of the world, if that product gets incorporated into another product and then ends up being in the US market, it may be possible to trace out a US effect. And there are multiple cases on that front. And it's very much an effects-based analysis and a jurisdictional question, as Heather said. But it is theoretically possible that you could trace out that jurisdictional nexus. And since you've already complied with the exemption and indicating that you're coordinating your pricing, then that would be very easy to prove that you've been operating as a cartel. So it would just turn into a jurisdictional question.
Very interesting, thanks. And I mean, HB, we've already seen a period where South Africa has become more protectionist. We've seen lots of action from ITAC in order to impose safeguard duties in industries like poultry, and we're now seeing a big revision of steel tariffs in order to try and protect the local manufacturing base. Is this a trend which you expect to see continuing in the coming period in response to this kind of global unsettled environment?
Thanks, Heather. Yeah, that's actually a very good question. And we had a discussion about it yesterday with one of our clients. And it's I think ITAC finds itself in quite a awkward position at this point in time, because there are some historic investigations in relation to various sectors. And if we talk about steel as an example, now if there was any proposed tariffs, and if you even have regard to the recent report that they published, it's an interim report, but I think they're stuck between a rock and a hard place, because by imposing stricter tariffs, not in relation only to the import of steel, but also in relation to the export of steel, will just add additional cost on cost on cost. And you won't probably see many producers, and it's not only at the level of steel producers, but the various end users that they supply. And I mean, that's got a ripple effect right down to automotive manufacturing, to even wheelbarrows. So, by imposing additional stricter tariffs might, in fact, create even a much more of a barrier for exports to other countries like Asia and Europe. So I do think while ITAC was quite set on a specific approach regarding the imposition of tariffs, they now have to deal with the realities of making sure that locally, that importers specifically, and and whoever they supply remain viable in the local economy, and also to achieve the greater economic objective, and that is there's obviously the protection of job and promotion of small and medium-sized enterprises. So I do think they're sitting between a rock and a hard place, and that's why they've asked for a second round of comments from stakeholders on the steel industry investigation. So we'll have to see how that plots out.
And of course, the Competition Commission has announced a market inquiry, although it seems like they haven't yet got going in full force of that on that inquiry. So we may see this kind of tension developing between the competition enforcement, which is focused really on kind of delivering benefits for consumers and promoting competition, and these kind of very complicated policy choices that are being applied by the minister and based on recommendations from ITAC, right?
That's absolutely correct, because now we've seen as recent as earlier this week that some of these scrap metal producers bring an interim relief application against ArcelorMittal for not only because of the government bailout, so to speak, but the fact that they are now in a position to sell at a much lower cost, but not necessarily benefiting the local consumers of this price advantage that they're going to experience, and it's going to even get more prominent as tariffs are imposed.
No, absolutely. And of course, Golani, I guess all of this talk of protectionism and tariffs is exactly what we are trying not to aim for in the context of the African Continental Free Trade Agreement, right? It seems a completely contrary impulse.
Quite right, Heather. As the world, I suppose, as the North decides to close, we're saying we are open for business, right? Yes, there's going to be challenges in the immediate short term. Infrastructure, whether it's ready. There's going to need, for example, that logistics services providers, for example, shipping lines need to move assets to regions that weren't being serviced before, just to be ready for those trade flows. Trucking companies and for those that do by road. There's going to be payments issues, which all those players, I can tell you, are geared up and gearing up to be able to facilitate that seamless trade and to be able to transact in local currencies, for example, without having, because one of the practical issues that certainly we'll need to be able to deal with is the shortage of US dollars in certain jurisdictions. But that is, I think we're all ready for. I suppose the question with that if I abuse the floor whilst I still have it, is, well, is there a world in which we could go back to normality and where Africa in particular trade with the US under its previous scheme, which is the AGOA, the African Growth and Opportunity Act? That is a question mark, because as we all know, AGOA is expiring at the end of September. There was a massive push by African countries, including South Africa, to extend that, I think, for like another 20 years or something period. But, whether, because these tariffs have been imposed during the subsistence of AGOA. And so while my view is that AGOA is dead, my colleague Hulufelo said, listen, it's not dead. It rather, there is a tariff preference erosion. So that is the more sophisticated, more nuanced way of looking at it. But I think the boat might have sailed, at least in the world of AGOA as we knew AGOA. But Africa does and is open for business.
Thanks, Kalani. Well, I'd like to extend a very sincere thanks to all of you for joining our panel this afternoon. It's been a fascinating discussion. I think the session highlights just how many opportunities are potentially available as a result of this block exemption. It certainly seems to be a push on the part of government to really facilitate the better ability of South African companies to export their products, and of course, as HB pointed out, not only to the US but globally. So lots of opportunities there. But I guess this highlights that if you think you need to use this draft block exemption, you've got a very short window now to get your comments in. And in particular, I guess those comments should be focused on making sure that the block exemption actually covers the conduct or the business practices or the agreements that you want to enter into. So you've only got a little bit of time there. You better get scribbling on your comments. And then, of course, as Xolani highlighted, once you seek to use this draft block exemption, one needs to be very careful and make sure that you comply with its terms and that your conduct falls within the scope of it. And also that you have these ongoing kind of compliance mechanisms in place. And then last but not least, as Hugh was emphasizing, that this may, of course, raise some significant antitrust risks in the US. And of course, not only in the US, there may be similar principles applied in all sorts of other jurisdictions across the continent, including, of course, now in Africa. So definitely the need to think very carefully about these collaborative kinds of conduct and make sure that you have taken advice where you need it. So a big thank you to all of our panelists. I'm sorry we weren't able to give you some more airtime this afternoon, but we appreciate your time very much. And thank you to all the participants that joined us, and especially for those who sent us some questions. We hope to see you next time. Thanks very much.
Thank you, Heather.
Thank you, Heather. Thank you all.
Thanks, everyone.
Bye.
Bye.
Bye all.